All righty. Let me spot.
The Vauld Creditors Alliance. Okay, we are recording now. Welcome to the VCA Ask Me Anything session number 1. We will be conducting these sessions every Thursday for the rest of February. It's our aim to educate and get feedback from the Vauld Creditor community. I've got a very short presentation I'm going to go through, and then we're going to introduce the panelists and then open it up for Q&A. I'm Bill Dorfeld, and thanks for joining us. First of all, our ground rules for today is we're going to try and keep this to 1.5 hours, all right, to respect everyone's time. As speakers speak, I believe the approach will be raise your hand. Alexi, our tech person, will select you and enable you to speak. I'm not sure if the video capability will be there. We will work that out. Please be patient with us. And if we get through everyone, we can go back for round 2 of 3-minute sessions. So that's a general guideline. We just want to respect everyone's ability to pose their questions. Let's all please stay professional. And we aim to post the slides of this presentation as well as the recording later on. We're not sure how many days the recording will be live, but we'll let you know once we get there. And as I said, we're going to have future AMAs for the rest of this month. So the agenda for today, guys, is to introduce the VCA, briefly look at what the plan is. We're going to talk briefly about trust issues, because that is the key thing behind all of this. And we will then introduce the panelists and then go right into Q&A. So first of all, about the VCA. As many of you know, I launched the VaultCreditors.net site January 11th in concert with the release of a very detailed report exposing a lot of issues with how Vauld and Kroll have been managing the restructure. Why did I do that? Well, for those of you that experienced the January 5th, 2023 debacle of the AMA that was held there, it raised a lot of questions as what's going on here, besides all the other things that were going on. So I felt it necessary to walk the talk, as for months, really, I was advising the COC and others that, hey, we really need a site that has all the information for Vault creditors to go to. So I finally went ahead and built that. Immediately thereafter, some wonderful people started coming to me to talk about forming an alliance to move it to the next step. But that's how this all started. Why the VCA? Well, it was an outgrowth of this initial website, and it was a group to basically form an alliance of like-minded people to take some action to get a positive outcome. The VCA launch just occurred a few days ago, so this is new and fresh, but we've been moving extremely fast. We've collected a massive amount of information. Hundreds of hours of effort have been put into this at zero cost to creditors. And it's going to stay that way, guys. This is an all-volunteer effort by fellow creditors like you. It's just we're trying to do something about it to help us all. What is the mission of the VCA? It's to research, report, and act on matters pertaining to the restructuring of Vauld. And what's our goal? We're all about goals and results. And it's basically, guys, to ensure that you creditors receive accurate information, swift action, and fair treatment, resulting in maximum return of our funds at the very lowest cost. Long story short, we just want our money back. We're not looking for revenge and other stuff that people are claiming. We just want our money back. So our members consist of 11 persons in our management team, some of which are attending as panelists in this session. You will meet and speak with them here shortly. Then we have contributor members. That's people who donate some money to the VCA fund to help us with legal funds. And then there's associate members. With respect to the membership, we have over 370 members, consisting of over $46 million asset under control. And you kind of see the breakdown by region of these assets. We are not sharing names and email addresses associated with these numbers. It's for purposes of knowing what kind of representation power we have. What is the role of the VCA managers? Well, our role is to set policy and strategy for the group of membership and to act in a transparent, active, and engaged manner. With respect to info sharing, our strategy is to maintain the VaultCreditors.net website with a ton of information that is carefully curated, and then outreach via email. and constant engagement via social media and through frequent AMAs as we're doing right now. We cannot guarantee, and no one can guarantee that every single question posed on social media, especially Telegram, will be answered. It's impossible for any one of us or any group to do that. But I guarantee you, we do respond to every single email sent to info@vauldcreditors.net, and we'd love to hear from you. So what is the plan? Well, the VCA plan is simple. Find a way, as we will discuss, to remove Vauld management and Kroll as soon as possible. Stop the burn, as you see on some of our panelist screen. It's to stop the mismanagement and the draining of our assets. So we have to clean house. Step 2 is to cease the moratorium extension. Step 3 is to apply for a winding up application through our legal counsel. And step 4 is to take control through a liquidator to immediately reduce monthly costs. Step 5 is the process of a committee of inspection formed by vote of creditors, and the liquidators who are present with us today can speak more about that. And they would then perform an independent financial review and then work right away to recover and distribute our assets back to us. Through that whole process, we would hope to have the VCA still engaged in some communicative type of manner. Whether or not we are appointed as part of the committee of inspection, that's irregardless. We'd like to remain in the process to help share information to the community to make it easy. So I'll talk briefly about the VCA fund. The initial contributions have come from us managers. We're kicking in our own money to hire the lawyer to move things forward. And we have opened up for contributions. And thank you to many of you who have contributed, much appreciated. You are then contributor members. The cost quoted to us is approximately 11 to 15K to get legal help to end the moratorium, 7.5 to 11K to apply for liquidation. If that goes unopposed, that's it. No more legal fees. We go to liquidation, and the liquidators can talk more about that later. The VCA fund, very minimal operational cost. Basically, I'm paying for it all right now, about $500. It's definitely going to be under 1,000. I'll probably just eat that and pay it. But just disclosing how much it costs to run this kind of organization, so that you know what our commitment is. We invite you all to contribute to that URL. It's very easy to find on our website. And our legal counsel has said there is an opportunity, subject to the liquidator and their policies, to reimburse a portion of your contributions of legal fees in a future distribution as part of the asset recovery distribution. Guys, I want to take a short bit of time. We're just 9 minutes into this, and we're going to get to Q&A real quick. But I want to raise the questions of trust, because for many of us, that is the key issue in all of this. Who do you trust? We're going to do an A/B comparison, Vauld and Kroll versus the VCA team, and the team meaning our legal advisors and the liquidators with whom we want to work with. And on that note, folks, we have interviewed over 5 legal firms and settled on one who's fantastic. And this is over a period of 3 weeks, literally combined hundreds of hours of research and meetings. And same with liquidators, licensed insolvency practitioners. We've interviewed 5 of them, and we're lucky to have one of them joining us today, who is our top pick, KordaMentha, who represents other crypto asset recovery issues. They will speak very pointedly and intelligently regarding how they operate. And I know that that's what you guys all want to be hearing, and we're going to get to that very quickly. But I would appreciate the opportunity to show an A/B comparison with respect to how we operate and how the other side, not to paint them in a bad picture, but this is why we're doing things. On one side, there's been consistent lies and misrepresentations. We're all about well-documented facts, keeping it simple. Broken promises versus delivering on promises. Delay versus a very rapid pace. Guys, we've only been active for just over a month. And if you look at our website, you see the amount of information we're sharing. We move quickly because we want our money back. The CEO of Vauld is a 3-time failed CEO. A lot of the people as part of the VCA are very successful entrepreneurs that have launched multiple businesses. We know how to operate a business. There's been limited creditor resources available both to the COC and elsewhere. We provide a bountiful amount of creditor resources, And there basically have been inadequate tools and resources applied, and especially with the COC, they were not given resources to do the job. No replies on one side. We do respond and will continue to respond to every email. And one of the affidavits had Sanju complaining about receiving 152 emails per week, even though they have 50 plus employees. Guys, I get that in a day and they get responded to. And I know many of my high-tech colleagues will say the same thing. So these are inadequate excuses that they've been delivering in affidavits submitted to the court. Enough with the BS. Here's the reality. We will act and have been acting professionally. Then there's the instances of them feigning as a AMA held live versus a real live AMA, such as we're experiencing right now. One could go on and on. The COC, secret society, not disclosing the names of the members, their identities, who knows who they are. Some have stepped up versus full disclosure on the VCA, transparency, concealed financials versus an open book. We are showing you who has contributed to the VCA. We open one source of info, Vauld and Kroll versus multiple sources. We have, like I said, interviewed multiple independent liquidators and law firms to establish our decision-making for our personal recovery of our funds, and we are sharing that with you at no cost. I won't go on anymore to kind of badmouth, but just to point out the differences. And in the end, guys, the very last point there, $3 million of our funds have been wasted, drained by Vauld and Kroll over the last 7 months, while over the last month, what we've done with VCA has cost you guys nothing. All right, just pointing out the difference. So who do you trust? A and B. I know trust is a big issue, and I'm not trying to sell you anything. We're just trying to provide you free information. So let's go to the, so I did that in 12 minutes. Let's go on to our panelist intros. The VCA management team, it's also posted on our website. It includes this following list of 11 members, some of which are here. The combined, I think the combined value we have is around 7 million in assets under control just within this group. There is one top 10 creditor here. And so we have a very vested interest here to get our money back. But getting your money back is also important to us. So at this point, thanks for allowing me to spend 13 minutes introducing the VCA. I'd like to now introduce our key panelists, KordaMentha, who are licensed insolvency practitioners specializing in restructuring and liquidation services in Singapore and elsewhere. They are engaged in comparable restructures and liquidations. When I say comparable company to our Vauld situation. And without further ado, I would like to open the floor to Cameron and David to quickly introduce their firm. And then if they would be so kind as to give us a quick summary of the difference between a managed wind down and a winding up liquidation scenario. So let's go ahead and turn it over to KordaMentha. Thank you.
Great, thanks, Bill, and good evening and good morning, everyone, depending where you are. Yeah, as Bill said, my name is Cameron Duncan. I'm a partner with KordaMentha here in Singapore. I'm joined by David Kim, who is an executive director, also in the Singapore office. Just by way of a brief introduction to KordaMentha as a firm. So KordaMentha is a financial advisory firm. We help companies grow, protect, and recover value. The name of the firm comes from a couple of senior partners from Anderson in Australia who set up the firm around 20 years ago with Anderson COVID. We have around 400 professionals across the Asia-Pacific region. I myself moved up from the KordaMentha Sydney office 14 years ago, so I've been to Singapore ever since, and David's been here for about 9 years. So when I say grow, protect, recover value, our focus here is in restructuring, which is both formal and informal restructuring. And as Bill said, we are both licensed insolvency practitioners to take appointments in Singapore. We have been involved in a number of recent matters in crypto. And perhaps just hand over to David to perhaps talk through some of our experience in those matters.
Thanks, Cameron.
Cameron, sorry to interrupt, gentlemen. Is there a way you could get your microphone a little bit closer so we can hear you? It's hard to hear everything.
Oh, apologies for that. Is that a bit better, hopefully?
Feel free to, yeah, a little better. Feel free to speak up. So yes, thank you. Go ahead.
Thanks and good evening or good morning, everyone. So my name is David Kim. I'm, as Cameron introduced, I am an executive director with KordaMentha. Just to give you a bit of flavor about our experience in crypto related matters. You know, as we are all aware that Terra and Luna back in May was a catalyst for a number of restructuring matters that came through. So we, essentially from that point onwards, we have grown our expertise in crypto-related restructuring matters. Probably the most comparable matter to the current situation, we are undertaking a similar process as Vauld for a company called ZipMex here in Singapore, which has predominantly creditors in Singapore, Thailand, Australia, and Indonesia. We are currently undertaking the restructuring whereby there is an investor who is on board, willing to invest into the ZipMex business to keep the business as a going concern. We have undertaken a number of innovative ways to deal, especially with the large volume of customers. So in total, there are about 300,000 listed customers at ZipMex, of which 70,000 are currently undertaking the scheme of arrangement process. So, obviously using the traditional methods of, paper, claim forms and ballots just was not possible in this situation. So we have innovated to use online methods where customers can essentially fill in the data, and that essentially the data is exported into an Excel sheet, which just makes it so much easier from our perspective to do matching of claims and validation of the numbers. In addition to that, we've also explored a concept called administrative convenience class. So essentially what that is a US provision that allows for creditors that are owed a small amount. So in the ZipMex situation, we've left it at US $5,000, will essentially not be required to participate in all the scheme process, fill in the documents and all that. And they still get the full benefit of the outcome of the scheme. So in the ZipMex situation, whilst it is still undergoing the court process, the expected outcome is that all the customers will be able to get the same equivalent amount of crypto that they held in a separate product that ZipMex had in full. So without taking into account any changes in prices, if you had one Bitcoin in that wallet, then you get access to one Bitcoin back. In addition to that, our Australian office are undertaking two matters. One is the administration of FTX Australia. The second matter is another Australian-based crypto exchange called Digital Surge. I think FTX is still running its course because of the Chapter 11, but just to give you a flavor on Digital Surge, what is happening on that matter is that, again, our team was able to get an investor where, whilst it's not 100% return on the crypto assets held, very quickly they were able to source an investor that was willing to make a distribution. So the initial distribution will be about 55% of the total amount of crypto. It appears to be an in-specie distribution that will be done for that crypto. Then the balance of 45% over time may be a cash distribution, just depending on the realization of other assets. So whilst the idea of crypto restructurings is still relatively new, I think that from our experience in the last 8 to 9 months, in particular with ZipMex and with some of these matters in Australia, we are by far ahead of many of our competitors in understanding and the steps that we would be able to take to make sure that a restructuring or a wind down of a similar business like Vauld can be done as expeditiously and efficiently as possible.
And just, I guess, picking up your other question, Bill, the difference between a wind down and a liquidation. So, you know, we are looking at a different situation, I guess, with Vauld, with ZipNext, we're able to bring an investor in and there's a different outcome there, which, you know, it's very much in line with the scheme of arrangement process to enable the, you know, essentially the new investors. This is a different situation with Vauld. So, I mean, I guess just to clarify, with the liquidation, we're not talking about a fire sale. In fact, it's what I'd call a managed wind down can be achieved through a liquidation. And, you know, liquidators have obligations to creditors and to the court to act prudently, and they certainly manage the wind down efficiently. But essentially, you're looking at a very similar sort of set of processes. I mean, in all cases, you need to know who the creditors are. So you need to make an assessment of the claims. You need to make an assessment of the assets and the best way to realise and or distribute those assets, and then you need to effect the distribution. I guess the additional step you have in a liquidation is you investigative component where you look at what went wrong and you report to creditors on that basis. So, I mean, I think in terms of how you do those key steps, you need to look at innovative ways to do it. You know, we're dealing with a very new class of asset that is globally new, and the courts are, you know, wrestling with how to apply the laws that are in place to dealing with this new situation. But I think the courts in Singapore are very adept at you know, looking at these new situations. I think you need to come up with the innovative way to administer the liquidation. That's the path that you're going down, and present that with a commercial basis and a legal basis to the court to get the court's blessing. You need to do things differently that may have been done in the past. But I think the first step is to put your mind to it and come up with those ideas, which, you know, it's a different situation, but we certainly tried to do that on ZipNext, and we're happy to answer further questions on some of the things that we have done there that may.
Okay, Cameron, we're really having difficulty hearing you. If there's a way that you could get even closer or bring the computer. We were hearing David pretty well, but I think it's the distance from the microphone that is causing the issue. What you're saying is very important, and we want to make sure all the attendees can hear it. Really quickly, before opening up the floor to attendees, and while we're still kind of doing an audio correction check, could you explain some of the benefits of going with a liquidator to manage the liquidation or a managed wind down through liquidation versus what we understand Kroll is proposing, which, by the way, attendees, please understand the latest version of the Kroll proposal was just delivered this morning. We have a basic understanding, quite a good understanding of it, actually, and some of our other attendees will speak to that. Our KordaMentha friends here haven't had sufficient time to really review that and comment on specifics, but we'd like to focus on the general concepts of their idea of managed wind down versus what you guys could do versus a liquidation event. And could you please elaborate on the whole idea that you've shared before, so that our attendees are aware of how a liquidator needs to post a deposit with the office that controls these matters in Singapore, and how basically you're on the hook for that. It adds an additional layer of security and safety to creditor funds. Could you elaborate on that and help people understand the process from that standpoint?
Yeah, no problem. So, I mean, under Singapore law, once a liquidator is appointed, they're personally liable for the debts that they incurred. So, yes, very much we have skin in the game to ensure that we manage liquidation on a very prudent basis. And, you know, I guess just to reiterate, and apologies if it wasn't clear what I was saying earlier with the sound issues, but, you know, the liquidation is not a fire sale. It's in a sense, given that prudence that you need to exercise and your obligations to the court and obligations to creditors, you know, you need to manage the sale and distribution of assets very carefully. So it's a managed wind down in that sense. Although, you know, I understand there's a different, you know, definition of what a managed wind down is in the proposal that has been provided, but it still involves those same steps. It's an assessment of claims, it's a assessment of the assets, a realisation of the assets, and distributing the assets. And it's how you apply your mind and give thought as to how best to achieve that is, I guess, the difference. And we believe there's ways to do what is not the sale of an ongoing business. You liquidate the assets anyway. You look at the options that have been put forward in this Vauld situation using the liquidation mechanism, and we think it can be done at a reasonable cost. And there's some assumptions that have been made, I guess, in the assessment of the liquidation option, which I think could probably be done in a different way, which may be more cost effective. And our thought is that it would cost less to do the liquidation option than what's currently being proposed.
And so everyone has a very concrete and clear idea of the differences. The managed wind down proposal from Kroll is through a scheme of arrangement, which would require multiple steps, explanatory statement, a vote amongst creditors, et cetera, which they projected over a 6-month period at the very least. But on a court-ordered liquidation through a creditor recommended or nominated liquidator, would that not go more quickly to then get an independent financial party in there looking at the books and looking at the agreements and save on that whole layer that would be involved in developing a scheme? We're not talking about a scheme of arrangement. We're talking about a court-ordered liquidation.
So generally speaking, the timelines are driven by the court in respect of when you can get the hearing date, and it will also depend on opposition. But what we generally find that once a winding up application is made by a creditor, the courts will generally hear the application generally within 3 to 4 weeks of the application being made. And if the court is minded to do so, then at that point, they will take steps to appoint the nominated liquidator to take over the affairs of the company at that point.
And in so doing, that would save that whole level or layer of costs associated with pursuing a scheme of arrangement. So let's find a way to open the floor for questions from attendees. Alexi, do we have some questions lined up where people can actually speak so we can start getting engagement from them?
Let me get some clarification. So attendees are welcome to submit a question in writing through the Q&A, or if you'd like, you can raise the hand and I will give you the floor. For now, I have a Robert raising the hand. I will allow you to talk. Robert, please go ahead.
Hi there. Can you guys hear me?
Yes, sir.
Yes.
Yep.
Loud and clear.
Perfect. Hi. My name is Rob. Thanks for, first of all, for the work all you guys have done. One of the main questions I have, I attended the session this morning of Vault as well. And of course, the issue there is on trust and this which Vault has been making. My point basically is, of course, Vault currently has kind of the lead in the process with the judge, etc. And with what they have been proposing this morning, they are moving more and more towards this managed wind down, because I do think they feel the heat from a group like ours that they have to move towards this. But the question or the questions I would like to ask is more of the what are the chances we have on our side to push forward with the plan there is. And I mean this from multiple perspectives. One is, okay, if we appeal to the court to end the moratorium and apply for this liquidation, one, is there a certain majority needed? If we represent about 15% in US dollar value of the claims, is there a majority needed, or how does that work? What will make the judge move towards going for our plan? That is one question I have. Two, of course, the company, Vauld and the CEO and whoever is there, they have a lot of knowledge and access and keys towards the current situation. If we take this over, what kind of risks are involved in there for the recuperation of the money? It's although I am very much in favor of us getting into the lead, I also want to be look at a fair and honest way, like what are the chances with the situation that is there, that we can actually make that happen, or are there risks involved taking over, which results in it becoming more difficult to recuperate that money in certain ways? I have more details, but those are in the big lines, the questions that I have on our chances, and I'm curious if the law firm could give us some insight on that. I hope I was clear.
Right.
Thanks.
Thank you. Thank you.
Thanks, Robert. I'll go ahead and lead and help on that. And to be clear, the firm that's here with us is not a law firm. It's a licensed insolvency practitioner. They're a restructuring firm. So just to be clear there, with respect to chances, 25% opposition is needed in assets under management in order to block any motion from either side. And the key thing is not looking at the total pot of 300 or 400 million, but the number of people that are actually engaged and will vote. If for the first moratorium, there was under 3,000 people that actually voted, 2,910 to be exact. And so, if we have more engagement and higher numbers, then the chances are pretty darn good to be able to oppose or block a direction that is not, in our opinion, creditor friendly. So that hopefully addresses that question. The question of, the CEO cooperating with the liquidator, he will be legally obligated to cooperate. And he is also on record of saying that he wants to cooperate and assist creditors. So it should be no different whether or not he's doing that with Kroll or with another party. And I'd like for the KordaMentha, the liquidators, to confirm that.
Yeah, that's right, Bill. So, once a liquidator is appointed, the liquidator, the power to control the assets from the director's point of view is suspended, and the power to control the assets is vested with the liquidator. But there are ongoing obligations for directors to cooperate.
Very good. Robert, any follow-up to that, sir?
Yes, do you see any additional risk with that? Of course, we would be, let's say, an external party coming in. Of course, Kroll has been engaging with Vauld from the start. Are there additional risk that will reduce our chances to recuperate certain outstanding loans? Assuming that yes, the CEO will cooperate, etc. Is there a risk in kind of removing the whole Vault management? What kind of risks do we see there?
I'll kick in, if I may, just as a business person and just using common sense. There's risk in anything. There's risk of them continuing to do what they're doing, which hasn't been in the interests of creditors. And there's risks of, if a new team comes in to try and take control, that they're going to say, I'm not going to cooperate. He's on record as saying he's going to cooperate. What you're saying right now is the narrative that they're putting out there. They say, stay with the current team because bad will happen if you change the team. I posit bad has already been happening, and we need to change the team. It's a common sense business idea.
Yeah, Robert, I'd just add, this is one of my big concerns as well, of what's the greater risk? And I think what you've got to understand is that if we're going into a court-appointed liquidation, then Darshan and Sanju will need to cooperate with whatever the court instructs. And also, we will have our own liquidation firm in place who is independent, who can ask these documents. So when we're looking at things like the counterparty A loan and the coin loan agreement, the major risk from my perspective is that we don't know what's in those agreements, right? So yes, there is risk to an independent party coming in and taking over a liquidation, but equally, are those risks greater or lesser with Kroll, who have achieved nothing over the last 7 months and are on a contingent performance fee to agree a scheme? Or are they lesser or greater with an independent liquidator. And the conclusion that I came to personally is that actually, given the complete inactivity for the last 7 months from Vauld and Kroll, the fact that we are nowhere closer to agreeing a scheme of arrangement, and certainly not one that would be in the interests of the majority of creditors, then that leaves me with the only conclusion that we will be no worse off going with an independent liquidator. Just to be clear, I mean, Darshan and Sanju, they've published the list of assets in its 9th affidavit. So if those assets aren't what they say they are, then he will be that's criminal to have lied in an affidavit to the court. So my view is those assets have to should more likely than not do exist. Otherwise, he's putting himself at great risk of going to prison for the rest of his life in Singapore, and that he will cooperate with a liquidator in taking control of those assets.
Absolutely, thank you. I have a few
No
more
problem.
detailed questions, but I will leave the floor to someone else now, and then maybe ask them at a later stage.
Thanks so much.
Brian, do you want to follow up and make an additional point on that last thread?
Did we lose Brian?
Can't hear
Oh,
you,
I'm
sir.
sorry. I'm sorry. Yeah,
You're good.
yes, Bill. Thank you. First of all, thank you for all the attendees who hosted tonight, and Robert, thank you for that question. I'm trying to field the Q&A, and please keep the questions coming and raising your hands. This meeting is obviously very, very important. I myself, among other creditors here tonight, have over 7 figures on Vauld. So, what we've organized is extremely important to all of us, and I can't stress that enough. And I think the clear question that we all need to ask ourselves is, coming this far with Vauld and, trying to cooperate with what they're proposing, and then obviously their lack of transparency is deeply concerning. And, we have 11 people on this alliance panel that really dug up all this information and tried to provide the facts. For me, it's just very simple. It's a clear-cut case of, do we want Darshan and Vauld to have control of our funds, any further or not? And for me, they've provided no transparency whatsoever regarding assets, liabilities, 7 or 8 months of basically stalling tactics. And it's, in my opinion, and take it for what it's worth, that it's all a stalling tactic in hopes that the crypto bull market will come back and obviously rescue Vauld as a fund, and hopefully they can continue on. It's my opinion that Darshan does not want to go into liquidations because he doesn't want the quote unquote bodies to be found where they're buried. I think there's a lot of misrepresentations and possibly some illegalities that perhaps exist. And with the liquidator, it's quite simple. We're going to get forensic accounting. We're going to get facts to assets and liabilities, which we to this day still do not exist. So as far as risk is concerned, I've worked with these gentlemen for over the last 5 weeks to bring this to this point. They're all highly professional people from all over the world that have huge amounts of money on this platform. And it's just, in my opinion, you have to ask yourself a question is, do you really want to go down the road with Vauld with a lack of transparency? We still to this day don't understand liabilities and assets. So to me, that's the most important question. Is I just want transparency. Obviously there's been mistakes that have been made in the bank run and so on. And at the end of the day, we just want our money back. And for me personally, I don't trust Vauld and Kroll to gamble with the assets that are left to make us whole. And everything that's been proposed at this point is just, in my opinion, just been absolutely absurd. So it's a very complex situation, and I understand the stress that everybody's in. Clearly, I'm one of those people. And, we have fielded so many attorneys and so many liquidators, and we've tried to provide the best of the best that can get this done in a very efficient and affordable manner. To do an RDA and to do what they're proposing at $40 million is absolutely absurd. It's absurd when we can do it for a fraction of that. but more importantly, get transparency of what is truly going on behind the scenes with assets and liabilities. Thank you.
Thank you, Brian. That was wonderful. And we will get to the liquidators here momentarily, because I know that's a pressing question for everyone. How much is this going to cost? And we'll respectfully ask them to try and give us some ballpark numbers there. Before we do that, we want to go to Jeff, one of our managers. And then I think it would be good. I don't see the queue of questions, but I think I want to do a quick tour of some of the managers to get their comments. So Jeff and then MJ, and then we'll go back to questions. Jeff, is that okay?
That's fine. Actually, yeah, that's fine by me. Actually, I was going to kick it to the liquidators here in a second anyway, because of I did see a question a minute or two ago that was very good, and I think I saw it on the Telegram channels earlier too, and it made a lot of sense. The question, I guess I'll do an intro for myself. Brian said some stuff. Jeff Hauerbusch, U.S. citizen, located in Puerto Rico. I've got about 800 grand locked on Vauld. Thought I'd have a nice fixed income product there, nice and safe, 150% collateralized, all that good stuff. With all the interest they're paying me, it's almost 900 grand now, so that's good. So that's racking up by the day. But anyway, by the way, guys, I just want to say one thing regarding the VCA. I myself, I'm not the kind of person that would do this sort of thing. We're creditors, just like all of you are on this call. We just got tired of all the the stuff going on. I'll just leave it at that. I was fine with it at first. They were supposed to get bought out by Nexo. I thought I'd give them time, see how it goes. You guys probably felt the same way and thought, someone will handle this. It'll get taken care of. And I'll get an email saying, move your funds to the. And after a while, you realize the mismanagement is so bad with this company. They had a very good website. It suckered a lot of us in because it was very well done, but they don't know what they're doing. And it's becoming more and more apparent. And that's why I think this group was formed. Thank you to Bill for that. And we have to do something. If we don't, no one is. And to the question about risk earlier, I don't want to harp on that. It's a great question. I understand where they're coming from. I do feel kind of like Brian does, that the greater risk is the guarantee of the risk if we stay with Kroll and Vauld, and they have been messing this up, I think, intentionally for a while. The question that was mentioned earlier about, I'm trying to think. Oh, they asked if in the case of a liquidation, do you need to sign away your rights to sue the company at the end of that process? I'm pretty sure I know the answer to that. But they're asking because everything that Vauld and Kroll is presenting to us, all these schemes, which today, I don't know about the rest of you, I felt like I was back in advanced calculus class in college as they were trying to explain the scheme of paying us out. And you have to I felt like it was like people with a shell game in front of you. You got to guess the right one or you don't get your money back. But you have to sign off on those, right? If you go with their scheme that they're presenting, you sign your rights away to sue at the end of it. And with liquidation, you don't, correct? I think that was the question, if I'm accurately presenting that was mentioned earlier. And I'll throw that to the liquidators.
Look, I'm not sure exactly what's being proposed in terms of for rights being signed away in a scheme, but certainly in a liquidation, the liquidator has wide powers to bring any actions on behalf of creditors against parties where there's been a breach of duties or there's been offences which would enable recovery. So yeah, there's certainly no waiver of any rights under a liquidation, whereas a scheme, perhaps that is the case in this situation.
Fair enough. Thank you.
All right, we have a follow-up question with Robert. I'll allow him to talk. Robert, floor is yours.
Thanks
Robert,
once again for the floor. Yes. Two questions I have also based on the call this morning. In case of a liquidation scenario, will it become harder because of the status the company will have in that moment because it's in liquidation to recuperate, for example, the outstanding loan of counterparty A versus the company not being in a liquidation scenario? It's a question for the liquidators.
Yeah, thanks, Robert. Look, we've only been involved in this and, had a first discussion 24 hours ago. So, look, I'm not going to pretend that we're across all of the detail of every class of asset and every potential claim. I guess we'd have to look at that more closely. So not really in a position to answer that right now. No? So I don't want to give you
Robert, I can chime in here as well, just to add, because we've obviously been having meetings with a number of law firms, and we've already appointed Rev Law as our legal representation. This was the key question that we asked them, because this was my main concern as well. And their confirmation to us is the fact that it doesn't change anything. If you're counterparty A, it makes no difference whether you need to repay that loan if Vauld is in liquidation or not. It doesn't matter. You have a legal agreement to pay. If they don't pay, then Vauld can initiate legal, even if they're in liquidation, we can initiate legal proceedings against counterparty A for the treatment of those assets. And if counterparty A still don't pay, then obviously they end up they would end up being liquidated themselves by the court, facing insolvency proceedings. We obviously, the speculation as to who counterparty A is, that's the company that it's speculated who they are has since raised capital. So I think we can be fairly confident that they probably do have the liquidity to repay the loan or repay the assets, as it were. And there's no difference in your legal standing. Rev Law, who are our legal representation, have confirmed there is absolutely no difference. In fact, if anything, we actually have a much stronger chance to retrieve those assets quicker, because there will be Vauld management, if they were in charge of the process, could potentially extend that loan, extend the maturity of that loan, and claim that they believed that was in the interest of creditors, even though it may or may not be. And there was some commentary in previous Vauld and Kroll slides about potential extension of that maturity. Whereas if we take control of the process with an independent liquidator and a legal firm who's acting in the interests of creditors, then we can actually enforce that that loan is repaid in the timeline that it was due to be repaid, which is actually in 3 or 4 months' time in June, which would make me much more optimistic on a large retrieval of significant retrieval of creditors' assets. That was one of my key questions to the law firm, and that's the answer that I've had so far. I can, if you're interested as well, please share your email address. I'm happy to set forward you. We've taken meeting minutes and notes of every meeting that we've had. It's been asked to a number of different law firms who have given us that same answer. I'll be happy to share that information with you.
Clear. Yes, I would love to. And if there is one follow-up question I could make, this morning in the session of Vauld, they claimed when it goes into liquidation, usually the payout of the claims will only be in USD, because it will all have to be converted, the crypto assets, into USD, because that the liquidators are not used to paying out in cryptocurrency. Mm-hmm. I have myself 6 figures on the platform, of which the majority is in cryptocurrency. It could be a big loss, so to say, if that gets converted at the wrong rates. So I'd like to hear if what they claimed there this morning is that true, or do the liquidators have a different view on that these assets can be paid out as their assets, how they work?
Yeah, look,
David,
we can answer that question. I mean, I guess the first response is that there's no prohibition against doing an in-specie distribution in a liquidation, and it happens in liquidation. One of the options would be to convert everything, but we don't have to. So I think we need to look at that and make an assessment of what is the most sensible and efficient way to distribute these assets. As I said earlier in my comments, this is relatively new. But the complexities that come across with cryptocurrencies, it's a matter of educating the courts. If you need to, there are provisions under the legislation for liquidators to make applications to court, where there's something that's uncertain or new in the law, to get the blessing of the court to do things in a certain way. And I guess it's just coming up with that concept and innovation of a sensible way to do it, and then following it through. If you need to make a court application to get the court's blessing, then you should be able to do it. But it's something that we need to look at further. But we're quite willing to look at it, and then certainly wouldn't say you cannot do it this way, because you can. It's possible.
Clear. Thank you.
Thank you for that question, Robert. I just want to encourage the people in the Q&A please raise your hand and we'd love to answer your questions live. We've got really good questions from Michael Toff and Philip and Denise. And these are all questions that honestly we'd love to discuss live and answer, to our fullest capability. So they're all good questions, and we, because we have an AMA, unlike the other group, you can actually ask questions. You're going to get, our best answer. So please raise your hand. We'd love to answer them, one at a time, and field those questions, please.
Thank you,
Excellent.
Brian. So should I move it to written question or give a floor to John and then Michael?
Do we have another person that's ready to speak that wants to?
We have two. Yeah.
Okay. Yeah. And if we could, before we go on to that, Johnny, if you, thank you for jumping in, guys. Johnny is in Singapore. He lives in Singapore. He's our lead along with Alexi in speaking with the legal advisors. Johnny, would you mind just giving a quick introduction to your background so people know who they're working with?
Yeah, absolutely. So my name is Johnny Edelman. I have been working in finance. I trade foreign exchange, currencies and interest rates. I've been doing that for about 20 years. I started at JP Morgan, subsequently worked at Goldman Sachs and Deutsche Bank, and now work for a hedge fund in Singapore with $3 billion under management, which I co-manage. So that's sort of my background. I have a finance background. Predominantly, I have 7 figures locked up on Vauld, so I have a significant vested interest in the maximizing the retrieval of those assets. And I, as Bill noted, I'm a resident in Singapore, also a British resident, as you can probably tell from my accent. Representing both, I guess, the European and Asian creditor community. Yeah, that's my background.
Thanks, Johnny. Alexi, we have a question coming up from someone. Can we put them?
Yes, I'd like to give a floor to John. He's been John Dorsey. Please go ahead. Please unmute.
Hey guys, can you all hear me?
Yeah.
Yes.
All right, great. Hey, first off, thank you so much for all your time and energy, all of you. Really appreciate it. I'm a U.S. citizen based in South Florida. Currently have 6 figures as well, locked up there in an altcoin, not stable. And so the 2-part of that question I have is somebody, one of you gentlemen mentioned 800,000 locked up earning interest, and I was doing the same thing, locked up in interest, but one would say if there was interest based just on 800,000 on USD, would they, if everything goes well forward and it's time for payout and there may or may not be a haircut, would he be getting only his 800,000 he had, not the 900 in interest he's earned? That'd be on that one. And then the second question with me, I'm in a coin, let's say in the next 6 months to a year, in theory could do somewhere between 10 and 50x in theory, and it's sitting there. How would I be paid back and what percentage at the time of they shut the lights off, or am I at the time of liquidation, what my account's valued at then? Because I'm looking at 6 figures now, but it could be upwards of $10 million US that I could have at the time of payout.
Well, I'll answer the first part. I'm not planning on getting any of that interest after July 4th. I think that's gone. And I think getting 100% even is kind of, that ship has sailed at this point with cable.
I can probably help answer that as well. I mean, unfortunately, given the situation the company is in, where the assets are less than the liabilities and have been since July the 4th, the general consensus amongst both the VCA sort of core members and broader creditor community that we've spoken to is that the only fair way to determine this is to say that whatever assets you had as of July the 4th. Why July the 4th? July the 4th is a date that Vauld officially, I know that previously they had prevented some withdrawals on a manual basis, but from July the 4th is when they officially announced they were stopping withdrawals. So at that point, you are unable to trade on the platform, you are unable to withdraw your money. So it makes sense that we use July the 4th as a snapshot date of the funds you had. Any interest earned after that, unfortunately, is interest that Vauld were promising to pay you, but with no ability to make good on that promise. And unfortunately, that applies to the same to altcoins you may have on the platform. So even if you have altcoin A and altcoin A with 10x from now to then, there wouldn't be any benefit for you. It will be taken as of the assets that you had on the platform on July the 4th. This might seem unfair if you're hoping that this coin goes up 10 to 50x. I would make a couple of comments on that. The first would be that, of course, it could also go to zero, so you do have the two-way risk, and you will still get the value of that coin as of July the 4th. The second is the fact that actually ultimately the coins that you had on Vauld were not necessarily being held in exact specie by Vauld. When you look through the asset list and the change in the composition of the assets, they had a mismatch between the assets and liabilities in terms of the composition. What does that mean? It means if you held altcoin A, they may have actually only held Bitcoin or even dollars against it. They weren't actually necessarily buying altcoin on your behalf and holding that in custody, which means that they wouldn't have ever been able to make good on that claim. And thirdly, and my third point, and I think this is the most important point, is we are in an insolvency process where Vauld do not have the assets to pay out on their liabilities. You are the liability, you're the creditor, you are the liability to them. You want to be paid your money. The quicker we can close this business down, which we have proven many times they've been very obstructive, there's potential fraud, there's been a lot of misrepresentation. I think the quicker that we get our assets back and you have your assets in your own wallet, or if you want it on your Binance exchange, you can have it on your own Binance exchange, you can buy that altcoin. And if it then does 1050x, you will own it and you will still benefit. But the best course of action from my perspective, at least, and from the creditors who I've spoken to, is the fact that I want those assets back under my control, not under Vauld and Darshan's control. And then I can repurchase those altcoins. And then if the coin does 10 to 50x, I know I can withdraw it and I can receive that $10 million. Whereas at the moment, if it's 10 to 50x is on the Vauld platform, I don't know what that actually means. I don't know if I'm ever going to get that money. Is that ever actually going to be received in my account? Or, what are the risks around that? So that would be my answer to that, my personal answer to that question.
Cold wallet, cold storage wallet.
No, thank you. Yeah, no, I transferred, let's say 1,000 units of asset X into Vauld. They weren't buying it on, I wasn't buying it on their platform. It was already there. So the 10Xs, 50Xs from there, I'm only getting a snapshot of what it was worth on July 4th is my understanding. And if it makes $10 million extra, that will help plug the hole for everybody else. That's where it's going to be an actualized, the assets are on their platform, so it's an actualized gain for them. You see what I mean?
I 100% see what you're saying. So and the issue is, and I would love to have a further conversation. I don't want to take up too much of other people's time, but I'd love to have a further conversation about this. But what I want to stress is the fact that you transferred those assets into the Vauld platform. When you did that, actually what happened is they went into Vauld's centralized pool. And it's quite clearly stated on their website. It goes into a centralized pool, which they can also effectively trade around in. They manage on a centralized basis all of their assets. And this is one of my big problems as well, is the company is called DeFi Payments, DeFi standing for decentralized finance. In fact, actually, this is completely centralized. It went to a centralized pool where they were managing their assets and liabilities. So actually, those coins may then have been sold by Vauld to buy some other coins. You lost control of those coins, unfortunately, at that point. I'm not saying that was right. I'm saying that's completely wrong, but that is the reality of the situation.
I get it now.
Yeah. And we can prove this because in the 9th affidavit, you can go through and see that the they've actually sold some Bitcoin because they were overly long of Bitcoin, and they've sold some Bitcoin and bought some altcoins because they didn't have enough altcoins prior to that to make good on their liabilities, i.e. your liability in that altcoin, they didn't have it. They have since gone and tried to purchase it, and there's been trading activity since where they're trying to match up their liabilities. But to be honest, having gone through the finances with a fine tooth comb, and we also have a forensic accounting team who unfortunately are based in Europe and so can't join us on this call because of the time difference, but they've been through it, and it's really not a clean, it's a mess actually. And the asset liability mismatch is a mess, and that's why the only fair way to do it is the way that we're proposing in our view.
Well, thank you very much for your time.
Thank you, John.
Yeah, I want to just elaborate on that last point that Johnny made. We have our forensic accountancy team in Europe, as well as we have MJ here, who will speak shortly regarding a forthcoming report that the VCA will be announcing based on our findings of a deep dive analysis of numbers back in August versus the numbers that we have now from the 9th affidavit. And it shows very clearly that Darshan and Vauld were engaged in trading with our funds, even when our funds were frozen, okay? They bought all meme coins, they sold the crown jewels, Bitcoin and USDC, and they bought this other stuff. We will have a report forthcoming very soon. It's under final review and it will be published. And I have to say one thing, I got a chat message from one of our lead European forensic team members who said, I didn't hear it because I wasn't on the AMA this morning because I was sleeping. It was 4:30 in the morning. But he said that Rose at Kroll during this morning's presentation explicitly stated that Darshan and Vauld have not engaged in any trading using our assets during the moratorium. We have the evidence to show that that is an incorrect, basically a lie. So I'll turn it over. John Dorsey, did you have a follow-up, sir?
No, sir. Just as we move forward and how else we can participate in voting and things like that, that you can dummy it down for all of us going forward. The worst subject in college I had was accounting. And the gentleman, Ted, the teacher brought me a desk. He's like, I've never had anybody get a 6% in an exam before. I said, well, what happened? He's like, everything's backwards. I said, well, if I flip it all around, I'll get a 94%. He's like, well, actually, yeah. So I said I was not going to be an accountant. I had to drop the class because you can't recover from a 6%. Try to get a C from there. But
by the way,
so I really
John,
respect you guys. So thank you.
Thank you,
John. If you want to have some fun, look into that 9th affidavit. By the way, it's all available on Bill's site, Creditor.net, Creditors.net. And if you look at page 130, there's a spreadsheet in there where they list their assets according to what they claim that they have. Like for myself, I looked at USDC. You can forget about my 800 grand. They only have $130,000 of USDC on their entire books. So when you're looking at your account, yeah, you're looking at your account and thinking that that's there. It ain't there, man. It's and I have one altcoin as well. I didn't even look at that because I don't want to know. So
Yep.
Alexi, I just want to point out, we got several people in the queue that
yes, I'm giving the floor to Michael. If
perfect.
Thank you,
I'm
John.
very excited to hear. I'm very excited to hear from Michael.
Michael, go ahead.
Michael, you're
Michael?
on mute, my friend.
Michael, you're on.
There we go. How's that? Everybody hear me okay?
Michael,
Welcome, Michael.
Okay, thank you so much. I appreciate it. I guess first and foremost, thank you to everybody. Certainly appreciate everybody's time. I think we all feel that way. So wanted to express my gratitude for everything that you guys have done up to this point. So I did see a quick reply back to one question that I typed in, and that is, and I guess really I'll phrase it this way is, I guess I just want to make sure that we're prepared for the upcoming court hearing on the 28th, and just wanted to see if there are things in place so that we're ready to present, because I think it's clear to everybody if you've seen the back and forth in the chats and everybody's got their opinions. And so really I think that what's going to win the day is it really comes down to sales and messaging. And we might be in the right. I mean, we certainly feel that we are. And Bill, thank you for the volume of information that you've put out, pretty much equivalent to being able to fill the Library of Congress, I think, up to this
Absolutely.
Exactly.
But and that's great. But I think that as we go in, we know that Vauld and Kroll are going to be loaded for bear, because they probably feel the walls closing in and they can feel the heat, and they know that this could potentially be one of their last opportunities to maintain control. And obviously we want to wrest that control from them because none of us trust them. So I guess maybe if anybody can just a couple of minutes, or maybe 30 seconds, whatever you're comfortable with, if you can let me know what we plan to present, how we plan to present that, so that it's clear, it's short, it's pithy, it's concise, so that the judge can digest it and the court can hear it, and it makes an impact on everybody. So
I'll lead, and then I want to turn it to Johnny, who's working on our key points document. Okay. And we'll let Johnny paraphrase that. But I want to lead by saying, because you mentioned the marketing message, because guys, we've had a very clear strategy, as everyone here can attest to. It's a two-prong approach. Win the hearts and minds of creditors, push on the legal side. Be ready for the end of February. So on the marketing side and the information management side, what we have been working on, you see the evidence. We have another report coming out to show the alleged fraud activity on finances. With respect to other things we're going to do, and to be honest, since this is going to be posted, do we really want the enemy to know our strategy? I agree.
I don't want, I don't want any sources and methods being revealed here.
There are some things coming that we're going to show some big numbers and huge amounts of support on pointed things.
Okay.
That will make it very easy for the judge to digest. Now,
okay,
guys.
Perfect.
Yeah. Thanks, Michael. We are focused on that. I'm going to turn it to Johnny here in a second, but just so you all know, this rampage of info that me and the team have been putting out, yes, it can seem overwhelming, but the judge has a legal obligation to look at the evidence and rule. He cannot ignore it. All right. And we have not had legal representation. Guys, you've probably seen those court hearings. I spoke at the last two, and a lot of these guys here spoke as well. We had 5 minutes to talk. When Danny Ong sat there and spoke for 1 hour, just regurgitating everything we already knew from the affidavits. Now, and we asked this of our lawyer, Mr. Chow Sui Tong, who's awesome. We said, "Are you going to get equal time?" And he said, "Yes, we're going to have equal time at the next hearing, my friend."
Okay, excellent.
Yeah. So that's going to help out tremendously. I timed, I listened back to that YouTube video of the last hearing. The judge gave us 5 minutes. I got 16 minutes out of him, but then he cut me. And guys, also, if you listen to that video, the judge was practically handing us on a platter what he wanted us to do. He was saying,
there you go.
Get organized, get your legal representation. He even said, listen to the video. Put together a bundle of information in case I ask for it. We've been doing all that, my friends. We are ready. We are focused.
So it'll be nice. Yeah, it'll be nice then to be able to hold up a template or whatever you want to call it to say, Your Honor, these are the 5 points that you asked for in the last hearing, and you know what? Here they are. You asked for this, we did this. You asked for that, we did that. I think that's great. That makes me feel much better. I'm very happy to hear that.
Great. Johnny, do you want to summarize some of the key points again, without divulging too much of our strategy, because this is going to be posted to the public here real soon?
Yeah,
absolutely.
Yes, of course.
Yeah, I'll just very quickly touch on a couple of points. The first thing is that, and I think I just want to sort of clear up, because obviously we've been speaking to the legal firms and the liquidators, and I just want to clear up some, people are perhaps unsure of how the process works. And so the process is that Vauld, and with their restructuring advisor Kroll, will propose a scheme. That's what they need to do. Once they propose that scheme, they need to have over 50% of creditors by number and over 75% of creditors by AUM to approve that scheme, for that to go forward. If that is approved, then that scheme goes into place. What that means, of course, and by the way, that is not all creditors. So it's not 150,000 creditors. It's only those creditors who participate in the vote.
It's those who vote, right?
As I think Bill pointed out earlier in a prior call, there was something like 3,000 creditors on the call. So you're probably looking at 3,000 creditors. So you're looking at 1,500 by number, and it's obviously unclear what AUM. The key for us is that actually what that means is to be able to block any proposal by Vauld and Kroll requires only 25% of the AUM of the voting creditors, which we are fairly confident actually now that we have a substantial sort of base of creditors supporting us. I think that would be the first point. And then if Vauld and Kroll cannot find a scheme that creditors agree with, then it goes to the court to decide whether he will extend the moratorium further for Vauld and Kroll to come up with another scheme which they can present, which creditors can vote on. This is how it works. These creditors don't have any control. It's only Vauld and Kroll who propose schemes, and the court and the creditors can then vote for or against. And the court, if it's for, then you go ahead with the scheme. If it's against, the court can extend the moratorium period.
Okay.
So our intention is to vote against the scheme, certainly as it's been presented so far, which is nothing like a managed wind down. It's a sequence of RDAs.
Sure.
But I need to go through the slides that came out last night in further detail. And obviously we'll need to look at the official scheme as it's proposed. From that point onwards, we will likely be voting against it. Everything I've seen from Vauld and Kroll does not look like it's in creditors' best interest to date. From that point, it will then be upon the judge to determine whether he extends the moratorium. As Bill noted, I think it was very clear from the justice in the last hearing that he is unlikely to approve significant further extensions unless there's good reason to do so. If the moratorium isn't extended, then at that point, there is nothing to do but to put the company into liquidation. That's what happens when the moratorium is ended and the creditor has to file a winding up proceedings, which we will be in place to do through our legal representation, which is Rev Law. We're already preparing the paperwork for that so that we're in a position to make that application ourselves, which will also give us some more control in the process in terms of nominating our preferred liquidators, who are Mentha on the call with us today. So that's just to sort of iron out some of the process, because I wasn't familiar with it either, and that's what we've learned through all these meetings with law firms, and hopefully we've saved you some time by doing this research, and then we can present it to you via these meetings. And then one other thing that we will be doing is obviously, as Bill noted, prior hearings, Danny Ong is often given a large amount of time to speak as legal representation of Vauld and Kroll, and creditors given less time. The reason actually is quite simple. Mathematically, if Danny Ong has an hour, let's say, and you have 12 creditors who want to speak, well, each creditor receives 5 minutes, then actually the creditors represented group have received a full hour, right? 12 creditors, 5 minutes. What we intend to do is have our legal representation, who is a fantastic lawyer, Chua Sui Tong. I'm pretty sure we can share with you his credentials. He is very, very experienced in matters of crypto nature, exceptionally experienced and highly regarded Singaporean legal representation. He will be able to speak. He will speak on our behalf. And so we'll be given a lot more time to engage with the justice in the hearing. And we will also be filing an affidavit to go alongside the ones that have been filed, for example, by Darshan and Sanju, and I know that Bill has filed one previously, and I think Brian did in previous hearings, but we will be filing a sort of shared creditor affidavit, just outlining some of the points that we feel are misrepresented. Unfortunately, we're working on that currently. That's I think Bill passed it to me because I'm putting that together. We have 21 very factual, evidenced points where Vauld have either misled creditors, misrepresented, or there are significant concerns and that have not been addressed in the last 7 months. And I think that will be fairly conclusive evidence that the moratorium should not be extended.
Okay, well, thank you very much. I appreciate that, Johnny. That's,
no problem.
There's certainly a ton of information there. And just one quick follow-up, and I want to be respectful of everybody's time. I'm sure there are plenty of other people that want to, get in there, ask a quick question or two. But when it comes down to us finally having the official vote on this whole thing, do we want this? Do we want that? When it comes down to that, does anybody know how that's actually going to take place? And I'm paraphrasing Joseph Stalin. I don't really care who votes or who they vote for. I just want to know who's counting the votes. So if this is another thing that falls under the purview of Vauld and Kroll, I don't want to vote that way because I don't trust it. So
100%.
Yeah, so the voting process will be, I'm fairly sure will either be undertaken by either by the court, but I don't actually think the court will do the voting process. I think it will be conducted by Kroll. But crawl are, regardless of whether you might be frustrated with them being slow, and perhaps they're incentivized to be slow because they're collecting fees. So maybe there are other reasons there, but actually crawl are a professional legal restructuring firm. They're not improper. So if they hold a poll and count votes, I do trust that legally they will report the correct outcome of those votes.
Okay.
But of course,
Thank you, Michael. We have 3 raised hands, and Brian, you want to jump in
Thank you.
first?
I just quickly wanted to just, to add to the group. We interviewed 5 law firms and 5 liquidators, and they, these people have combed through all the information that we have provided over the last month. And the consensus is from everybody that once this information is shown to the court, that the court actually has a fiduciary responsibility to end this moratorium. We have overwhelming evidence that basically shows, and again, five law firms, 5 liquidators that have no type of relationships with each other. The answer has come back exactly the same, that this is overwhelming amount of information, and a lot of liquidators and a lot of law firms have referenced a recent case in Singapore, the High Flux case, which is a large electric company. And, some of the things that were basically that led to legal precedents in Singapore. And the consensus out of all 10 people that we spent numerous hours with was this is a responsibility of the court based on the information that has been shown.
Thank you, Brian. We have Dennis, who's raised hands. Sir, your cue. I'm allowing you. Dennis, you're on.
Yes, can you hear me?
Yes, loud and clear.
Of course, I want to thank you guys for what you're doing. I'm here in Florida, along with some other people I've heard. And my concern is, are we able to, with Vauld it looks like from the meeting this morning with Vauld, that they're going to be trying to get a vote within probably the next 3 weeks. And if they get a significant amount of the creditors, then are we going to be able to are we vying for those same creditors? And if we need 25%, are you pretty confident we're going to get 25%? Go ahead.
Okay.
Understood.
Thanks.
Bill.
Yeah, thanks, Dennis, for that question. This vote that is forthcoming, that was just announced basically today and is effect today through February 15th, is a preliminary vote to gain guidance from creditors as to which of the many convoluted options that Kroll is proposing is what creditors want to pursue. Based on that preliminary vote, it's probably going to be managed wind down, what people from a majority perspective agree on. Then they will use that guidance to prepare their explanatory statement to pursue an application for scheme of arrangement to the court for pursuing a managed wind down, which is another form of liquidation. Okay. And at that point, and the liquidators, and guys, when we keep referring to KordaMentha as liquidators, they provide restructuring service as well. And I'm part of our professional KordaMentha folks here. We're just using it as a catch-all phrase, gentlemen. KordaMentha or whoever would be appointed, if Kroll proceeds with the scheme of arrangement, just to be very clear, then what happens is a vote goes out to the entire membership to vote on whether they approve or disapprove of that scheme. So
okay,
Dennis,
well, that answers my question. I must have misunderstood them this morning because it sounded like they were going to do this initial vote, which doesn't really matter. And then just shortly after that, they were going to be able to do the next vote. But what you're saying is they have to file with the court before they can do that vote.
yes, sir. And
Well,
that's why
it'll be a while down the road before the actual vote.
Correct.
Goes.
it's going to be a while down the road and lots of money to get there.
Yeah, I
Okay.
understand that.
That's filing a scheme of arrangement, which we don't want because it's burning more of our money. That's why we're asking for immediate court-ordered liquidation. Get the liquidator in there, shut this down, stop the burn. They're burning through our money. And if KordaMentha, if you would not mind chiming in to clarify timelines, because filing a scheme of arrangement and getting to a vote, is that not a multi-month process? Could you guys kindly confirm?
Yeah.
So just, I guess, from our limited sort of understanding of the current situation, I believe that what Kroll is proposing is non-binding in terms of the, the votes that creditors are making at this point. Generally speaking, for a scheme of arrangement, what needs to happen is that, as Bill mentioned, there needs to be a scheme document that is prepared. Again, that can take quite some time to prepare that scheme document. That needs to then be filed to court to get sanctioned to call for a creditors meeting to vote on the scheme of arrangement that is being proposed, i.e. the plan that is being proposed. In the alternative, there is a way to do this, which is called a pre-pack scheme of arrangement, which essentially allows for the creditors meeting part to be done away with, and the scheme document gets issued to the creditors earlier without the court's sanction because there's no sanction to call the creditors meeting. I guess long story short, this is not necessarily a quick process, and there are timelines that will come into play in respect of getting not only the court's sanction, but then the statutory requirements of calling the creditors meeting. Obviously an adjudication of claims needs to be done as well. And if there are any disputing creditors in respect of the adjudication, that process also needs to be dealt with. So it's not going to be, a couple of weeks kind of process. It will be a couple of months at least.
Thank you, David.
One other thing I wanted to
That
add to
answers
that.
my question. Yeah. And I have a better understanding now.
Thank you, Dennis.
I don't know how much time we have left with them. If I could add one thing, because I think there was a very important question early on, very early on. It might have been one of the first questions, and I don't think we got to it. Correct me if I'm wrong, but someone was asking about how Kroll has quoted this $10 million figure for liquidation, 10 million, 40 million, all these numbers. I thought they may want to address that with at least some sort of answer of how they feel about that number, and are they being accurately represented? Because I think these big numbers are being thrown out there to scare people away from liquidation. If they would like to address that while we're still on here.
Look, I think we can give our view on that, and we've seen some of the material that's been provided. We did see the figure of 40 million, and I think there was some statistics provided for the basis of that some liquidations in some other jurisdiction, which are not mentioned, the cost of 2 million a month or something. We certainly don't see those sort of figures, and as David mentioned at the outset, we are involved in a number of crypto matters. We don't see 2 million a month. I'm not sure how you would spend 2 million a month doing a crypto liquidation. And in terms of the 10 million fee, we are currently working on a proposal, and we'll share that in due course, but it'll be a fraction of that figure, significantly less.
Okay, thank you, gentlemen. And just in case people didn't hear that due to audio concerns, what Cameron was just stating is that this 40 million for projection on liquidation is just way out there. And then the 10 million even can be beaten, as he said, a fraction of that cost doing a winding up liquidation, court ordered, unopposed. Let's all be clear. If either our initiative gets opposed or their initiative gets opposed and there's some legal entanglement, the dollar figure goes up. But thanks for that clarification. Hopefully that answered that question. Obviously, the issue of cost is extremely important. And I'll add to that because they've been doing this. It's information warfare. They've been doing this now for weeks, is throwing out these crazy numbers, what liquidation is going to cost, and very low recovery numbers they've thrown out. even when they knew that they had updated information. So there's been a lot of, false portrayal. But point of fact, when they talk about some of these big numbers, it's with respect to Voyager, Celsius, these are US bankruptcy proceedings. And that would be one question for KordaMentha. Gentlemen, you have offices in the US. Is it generally more or less expensive to go through liquidation procedures in the US versus Singapore?
Look, I think generally, Bill, it's significant, costs significantly higher in the US compared to Singapore.
Thank you. It only makes sense to me, but when I see these numbers that they're talking, it's going to be so expensive. That's in the US where things are 3-4 times more expensive. So you heard it from them. It's not just coming from me. Should we go to MJ to give him the floor before some follow-up questions? Because am I correct in understanding some hands that are raised?
We have two more hands raised from Robert and Michael. LMJ.
Is that round 2 of these people or their first round?
First round. They never spoken.
Okay.
So MJ, if you don't mind, let's give a floor to Robert A. and Michael and give you the closing statement. Robert, you are on. Please.
And guys, not to interrupt, may I ask permission, KordaMentha, if we went a little bit beyond this hour and a half, are you guys okay, or do you need to leave here in 4 minutes?
I need to leave probably soon, but David can stay on.
Excellent.
Okay, thank you so much, gentlemen. All right, we'll proceed with the question.
I am already I'm already in round 3, so I'll keep it very short. I've communicated with Jeff over the past weeks as well. And what I think Michael was saying earlier, we have to market this further, I think, also when it comes towards voting. So I would like to also offer here, and I think everyone, like if there is any way that we can be of assistance in promoting this further with the Creditor group, please reach out to me, reach out to us, because only together we can make this happen. So I just wanted to let you guys know that I am here to invest time and money as well to make this happen. So just wanted to leave that message there.
Thank you. Thank you, Robert.
Thanks.
All right. Michael, you're on, please. Go ahead.
Hello?
Yes, Michael.
Yes,
Go ahead.
Michael.
Yeah, hello. This is Michael. I'm sitting here in Taiwan right now, and I have 59K with Vauld. And first of all, I just wanted to say a big thank you to all of you and to you, Bill, for doing all the effort and putting all the information together. I'm very happy about finally getting some movement into this matter. I just wanted to point out one thing, because as I realize, many people are still concerned that when we go into liquidation, we probably won't be able to recover illiquid assets or something like that. I think if you just look at the interest situation, I think a lot of us are tired, and I am tired that Vauld and Call claim we are all in the same boat and they are representing our interests. They're representing their own. The interest situation is exactly the opposite. Our interest as creditors is obviously to get our money back as fast as possible and as much as possible. Their interest is to keep kicking this can down the road as long as they can, because let's face it, if that matter is done, the second and Darshan will have the second or the third company, as far as I understood, put into the ground. What do they do after that? Yeah, they only live from our funds. Yeah, and Call also takes the money from our funds. It's not in their interest that we get the money back, or that we get the money back fast. They have exactly the opposite interest. I don't know how they can say we are on the same boat. It's not even the same planet.
They don't expect you to figure that out. They didn't think you would figure that out.
I just could not agree more with what you just said. And just to add more so as well, that Vauld are on a performance fee for agreeing a scheme. So they actually want to delay this process, and then they don't care what scheme gets agreed. It's just whether or not, and the key to that as well is not that they don't care what scheme is agreed, but that for them, they must avoid a liquidation, because liquidation is by definition no scheme. Which is why the presentation of the facts, the presentation of the cost of liquidation are so skewed, and we know they're wrong. We've spoken to liquidators. We have estimates from 3 major restructuring and liquidation firms.
That's why I don't mind which scheme they are proposing, because I know they are not representing my interest as a creditor. So I'm not
100%.
interested in any scheme or anything they're proposing. My
100%.
interest is that they give the money back and go, and that's it.
Imagine that.
We're totally
Imagine
on.
that.
We're totally on your page, and we're fighting for you. We're really fighting for you.
Yeah, thank you for letting
Thank you,
me point
Michael.
that out, and thank you for your great work. I'm looking forward to how we go on handling that situation.
Thank you.
Thanks.
It's a great point, Michael. And by the way, I think you guys, if you guys watched that thing this morning with Vauld, when they start doing their presentation of once they start getting into after the RDA, it's like advanced calculus. You've got to realize that whatever they're selling you right now is so complicated. There's a reason. They're trying to confuse people and trying to scare people when it comes to liquidation. There's only one reason they're doing that, you know, and it's not because they have our best interest at heart. I agree 100%.
Awesome.
Gentlemen,
We're gonna go to Brian here in a second. I just want to check in with David. Looks like Cameron had to leave. Please thank him for staying. If this goes for an additional 15, 20 minutes, are we okay there, David?
Yes, it's fine.
Thank you, sir. Brian,
David.
let's go to you. Let's go to you, and
So
then we're
I
going to
just
get
want-
to MJ.
First of all, we're getting so many great questions from the attendees, and honestly, you know, people are asking what they can do, etc. Our goal is to have as many people show up to that next court hearing, in basically in support of VCA. You know, simple things of just sharing the background and attending a court hearing. If there's 200 or 300 of us with this background, it's very powerful to the judge for one thing. And then more importantly, we didn't go out and hire a bunch of like no-name liquidators. We interviewed, you know, BDO is one of the big four. Deloitte is another big four. All these liquidators and accounting firms are all saying the exact same thing. Everybody who's on this call tonight are all highly intelligent people, and they're all saying the same thing. Like, enough is enough. At the end of the day, it really comes down to is Vauld and Kroll want to do their scheme for one reason. If we go into liquidation, there will be forensic accounting. And if there's a forensic accounting, I guarantee you there is going to be issues that are found. So that is their motive. That is their interest. And I'm not, listen, at the end of the day, I just want our money back. And I want everybody's money back in the most fair, quickest, and you know, form. Ideally, we'd like to do it in like-kind assets, which we have a proposal that we think we can actually do as well. So anybody who's attended this meeting tonight, I just encourage you to stay active in the social media groups. But more importantly, we will have other AMAs moving forward to get the message out. And our end goal, I believe, is to show up at that court hearing at the end of February in a very large number and show the judge that we are organized, we are educated, and we have legal representation, we have liquidators in place, and enough is enough. Thank you.
Thank you, Brian. MJ, would you like to add something?
Yeah, sure. Thank you. Good morning, good afternoon, good night, evening, wherever, which part of the world you are. I'm MJ. I'm one of the top creators in the top 10. And I have a lot of background in finance, technology, bookkeeping, accountancy, general ledger, banking and finance. My background is IT background, but I have a very intimate knowledge about finance, and I'm part of the legal and finance team of VCA. So long story short, according to me, since I'm coming from software industry, I was part of one of the startups which has the largest IPO in software industry. So I feel Vauld was a failed startup and should have been liquidated in July itself. It was stalled for 7-8 months, and we are stuck up with that Nexo deal, and it's time now to liquidate. There's no other option, basically. That's the fastest way to get the money. I was one of the creditors who spoke to the judge in November and pleaded that please allow the withdrawals. And I saw that it is possible, which is nothing but different than the managed rundown being considered right now. And I saw the future coming, and I was just requesting, because I was having financial difficulty. I have my entire net worth stuck at Vauld, and I was speaking for the creditors, fighting. I have the foresight, and I was very disappointed when in the next affidavit, Kroll had mentioned that it is not possible. When we know today it is possible. So the facts are right in front of you guys. And I was the first one to tell that Kroll is not freezing their liabilities as of July 4th. And I kept repeating, guys, Kroll's accounting and the way they are managing the assets and liabilities is not correct. And they gave a shock, including to the COC members, when they said, we are crystallizing the liabilities as of July 4th at $328 million. So that was not a surprise to me. I always knew that would happen because I was tracking Celsius, Voyager, bankruptcies, their COC meetings actively, although I did not even have $1 on that. And that was my investment in time to handle the case on Vault. And I was hoping that the COC would have the power as it had in the Voyager. I was very, very impressed by the COC team on the Voyager. And I predicted that they would have got the money by November if the FTX fiasco had not happened. And I still stick to my word. They will be the first one to get the money on the Binance platform very soon by March. So guys, I have been tracking what's going on in this, and you are in great hands. This team is very, very focused. We have vetted out the legal team and also the licensed practitioners for insolvency. I have personally gone into the details, and coming to the specific point on the cost, I believe we can do at a fraction of the cost. The liquidator we have narrowed down, okay, is based on technology. I'm coming from technology background, and I believe we can leverage technology. And these guys are very, very smart. I have asked them very, very specific questions, how to do it. And I see them thinking, improvising. And there's technology available. They have the software available. And just to give you an example, Midas Investments did the rebalancing of the accounts in 2 hours. It's on the internet. You can go and research it. So it's not impossible to leverage technology and do it at a fraction of the cost. We are in a digital age. We don't need to do snail mail. Okay, so the proposal given by Kroll is not correct. They don't have the background. They don't have the experience. We are very, very educated, focused individuals, and we'll make it happen. Trust me, I have my entire network stuck up here. I'm not going to leave anything unturned. So even today, what was told in the proposal, it's very, very confusing, even for a very, very expert like me. The unit concept is all bogus. According to me, that is too complicated. Also, they are slicing the assets into liquid and illiquid, which I think is not correct. The way they are just creating too much confusion and very, very difficult for people to understand. And I don't even believe a swap can happen. What they're talking about, that one-time trading, I don't think. And just to answer the question of the gentleman who was asking about the altcoin, in case you have seen that your altcoin is in the assets published as of December, yes, the community will benefit. And to add to that, we are basically a fund of one right now. Okay, that was run by Darshan, and we are all in it together. There is no bifurcation between stable coin holders or crypto holders. We are all into that, and we have a claim on the assets based on the liabilities. Whatever is your percentage based on USD, that's your claim, and that's what you're going to get. They have confused in-kind from day one. I had mentioned to Luke Thomas from COC that please ask Kroll to explain this in-kind. They never did. And I always said it is going to be in-kind in distribution. So you can look at the deck, which was published prior to today's call, in which they have created a concept called price on the day of distribution of the coin, which is basically you're going to get coins based on the market price divided, divide your claim by the market price, and those coins, you're not going to get the original coins in your wallet. So even the example today given by Kroll, by Rose, again, is incorrect. She said you're going to get 8 Bitcoins. You're not getting 8 Bitcoins. There are not 8 Bitcoins left. She made the same statement in the last AMA, which is also factually incorrect, and I can prove it to you. So these are concerns which make me very, very uncomfortable with what's going on. We got to stop this.
Yep.
Thank you, MJ.
Great, MJ.
We are 1 hour, 40 minutes. I believe
I think we're ready to wrap it up. Any closing remarks from any of our team members or managers? And actually David as well, sir, based on what you have heard, David from KordaMentha, do you have any closing remarks and things that you would like creditors to know?
Look, from our perspective, thank you for allowing me and Cameron to participate in this. And yes, just from our perspective, happy to assist if we are able to get an appointment as liquidators. So yeah, I'm looking forward to an open communication moving forward.
Thank you, David. And I want to follow up on one very key thing that MJ said, among many of the key things that he said. Technology is our friend. I used to own a web software company in the early days in the 90s of CGI interactions with databases. We did a big licensing deal with an Apple subsidiary. And so I know technology, and I respect the need for using technology to benefit processes. So when MJ says this kind of stuff, it's music to my ears. And I hope you guys understand that as well. Because the reason why we like KordaMentha so much is that they are already using this kind of technology to dramatically simplify the process of gathering claims, okay, verifying them against the company's own internal records, and then actually taking custody of the keys. They have a custodian, I forget the name, who can not only take custody, but then also make distributions. So we don't need to build platforms for that. We don't need to rely on Vauld's current platforms for that they're going to charge us $100,000 a month. We don't need any of that. We can stop the burn, transfer things over to a more efficient use. David, would you mind just clarifying the name of that custodial firm that you mentioned there last night?
So on one of our other matters, which is called Digital Surge, the cryptocurrency or some portion of the cryptocurrency was moved to a custodian called the Zero Cap. They are based out of Australia, but obviously can be deployed in this part of the world as well. So whilst we are open to other providers, they have indicated to us that they can not only store the custody of the cryptocurrency with insurance, but also they have the capability to do the distribution as well.
That's just wonderful. No other liquidators have mentioned that to us. They all indicate, well, we have a crypto team that could build something. Well, we like hearing that someone's already got it built and we could just move on to that platform. That means savings on dollars. There's a lot of business entrepreneurs here that think in terms of how do you maximize value? How do you save money? And the liquidator's primary role that I have learned just over the last several weeks is the primary role is to maintain value for creditors. They cannot work against that. What is Crow's primary role? It hasn't been working that way.
Yeah. We dealt with other liquidators that didn't know the difference between a stable coin and crypto. And when you hear that, you realize, okay, there's going to be a learning curve here. It's going to be steep. Whereas with this company, with David, they're amazing. They've already dealt with this. They have the systems in place. That's going to streamline things. So that's one of the reasons we went with them. So.
Thank you. Any other closing remarks from team members, or should we shut this down? We're doing pretty good. We're very close to an hour and a half. We're just an hour and 43 minutes.
Hour 40
good for you, Bill. Yeah, I would just like to say in closing, first of all, thank you for everybody attending tonight. And honestly, I think everybody who is part of the VCA and managers, we put in so hundreds of hours in meetings. I truly have, got the opportunity to meet you guys individually, but we've spent so much time together over the last month and a half. I honestly truly feel like your family. Sometimes we bicker and quarrel and have different ideas, but at the end, we always prevail. I couldn't be more proud of the amount of talent and great thinkers that are on this. And I think the most important message is we are just like every other creditor out there. And our goal is one thing, to spread the word that we are capable of ending this with Vauld and Kroll. It just takes numbers. Everybody who attended tonight, we need to spread this message throughout different social media groups, get more people to attend the next AMA, and spread the information that this is actual facts. This isn't hearsay. This isn't Kroll, smoke and mirrors, etc. Our objectives is one thing, is to end this, put as much money back in our bank accounts as we possibly can, and, you know, in kind, and then more importantly, just get some transparency and get the control away from Vauld and Kroll. So I'm very excited about tonight. I'm very excited about the people that we brought on board for the liquidators and the legal representation. They are, bar none, top of their field, and I am very excited for February 28th, and I'm very looking forward to our next AMA.
Thank you, gentlemen. That was great. We are 1 hour 45 minutes. Thank you all for attending, and we'll see you at the next AMA.
Thanks, everybody.
All right. Good night. Good night, everybody.